So we will start with studying the industrial property rights, first with the trademark. Our law defines the trademark as consisting of any signs like words including personal names, figures, colors, letters, numbers, sounds, and shape of the goods or their packing, provided that such signs are capable of distinguishing the goods or services of one undertaking from those of other undertakings and being represented on the register in a manner to determine the clear and precise subject matter of the protection afforded. So from that definition, of course, the trademark means trademarks and service marks, including the guarantee marks and the collective marks. Trademark is a sign. I mean, you see the name Adidas in a shape in your shoes. This is a trademark, which is protected under registration. And the purpose of having the trademark protected or having a trademark for a product, for an area of industry, is to distinguish the goods produced and or traded by an undertaking from the goods of the other undertaking. So that's how you distinguish the Adidas from the Nike, for instance. A guarantee mark, on the other hand, is a sign as a service mark that serves for the guaranteeing the common characteristics of the undertakings, production methods, geographical origin, and quality of those undertakings under the control of the proprietor of the mark. For instance, Institute of Turkish Standards, right, and ISO 2000 standards. The business institution would like to get the certificates that they are fulfilling the requirements of those standards, and that will help them to sell their products in a better way, easily. Collective marks, on the other hand, serves the purpose of distinguishing the goods and services of the undertakings belonging to a group from the goods and services of the other undertaking. Like, for instance, Tarish. We know that Tarish can produce olive oil, soap, every kind of things under the same collective mark. All of the, as I said, industrial rights is to be registered. They will be protected after registration, starting from the registration. Who will make those registrations? That is the case for the trademark as well. This is the Türk patent, and you have to file an application for the registration. But when you are registered a trademark in a national office, it will be protected in that country only. If you want to have it registered in other places, you have to take action in that regard as well. So there are requirements, formalities that you have to follow, and you will find that in your presentation in the respective law that will be uploaded to this learning system. You are kindly requested to go and check those parts. Of course, that you applied for a registration of the trademark doesn't necessarily mean that you will get that trademark registered in your name and you will acquire rights attached to that trademark registration. This can be rejected by the Türk Patent Office after studying your documents and your application. It can be rejected on two grounds, absolute grounds, and they are generally objective grounds that no one can say anything about that. There are very precise. For instance, if your trademark doesn't provide any distinctiveness, or doesn't have descriptive nature or descriptive characteristic that will distinguish your goods or your trademark from the other similar trademarks, and prohibition of the registration under Paris Convention. Certain registration of the certain things are prohibited by the Paris Convention. You don't need to know, but when you need, you can go and check whether this area is prohibited or not. And the Türk patent will make this examination automatically without requiring any request from anyone for whether the absolute grounds for refusal exist or not. Relative grounds, on the other hand, are not the objective. Those grounds related to the rights owned by the third parties. Most important relative ground, if you want to give an example, a ground for refusal is the existence of similarity between two trademarks, and that will create a confusion between the existing trademark and the trademark that you are trying to get registered. All of these industrial rights, including the copyrights, are protected for certain periods subject to certain procedural requirements. For instance, this protection for the trademark is granted upon your application for the first 10 years period. But this 10-year period can be renewed for another 10 years period, and of course it will. This is the only trademark will be protected if you keep doing that forever. But these rights will terminate upon the expiry of that term of protection that I mentioned. If you do not renew the rights in due time, of course you have to pay for that. This is the business, no money, no gain. By the trademark of owner's written surrounding of the rights, you can haul any part, you can give away those rights, and you can waive your rights. It is a general rule in the private law area. Or a court decision can declare your trademark invalid registration. Then you will not be able to, of course, enjoy the rights based on the registration of the trademark. What kind of rights we are talking about? The trademark owner can protect against the violations of the third parties. Trademark owner can prevent the manufacture, importation, sale, otherwise putting in the commercial use of the counterfeit products. And trademark rights may be subject to inheritance, so your son or whatever, your successors will be able to continue to enjoy those rights. Pledge you give as a guarantee. It can be seized, or you can transfer or give licenses for that use of that trademark. When you do that, of course, it will be non-exclusive. You cannot exclude certain parts. You have to give it whole, unless otherwise stated by the contract. If you want to exclude certain rights, you have to be careful about that. You put respective provisions into the contract that you are providing the license for the use of that trademark. Of course, infringement of the trademark, that's how the pattern that we are going to study that topic. It's violation, in other words. The trademark owner can demand, claim protection, request protection from the courts of civil law or the criminal law. And of course, I'm not going to go into the details, but if you, in the civil law courts of civil law, the trademark owner will request certain the protective measures like withdrawn of the goods, counterfeit goods should be withdrawn from the markets, seized at the customs, or destroyed upon the demand of the trademark, because it will be violating the interest of the owner of the trademark, or get compensated for their moral or immoral damages, pecuniary damages. And also, there are criminal consequences of violating the trademark rights, that the violator can be subject to a certain amount of imprisonment, starting from 1 to 3 years, or 2 to 4 years, depending on the type of the crime, and which is defined in the respective law. So it is a serious thing not to violate that.